Floor is resumed. Please be seated.
Get my screen up.
Good afternoon, Justice Hennessy. So just to finish off the discussion that we were having before lunch about the standard of review, I just wanted to finish off that conversation by explaining to you why two of the analogies that Ontario has raised in support of its argument on standard of review are actually inapplicable. And so that's the Crown prerogative and the duty to consult. So firstly, I'll discuss the Crown prerogative. And in this context, Ontario's argument is that they accept that this is not a review of a statutory power of authority, but they say nonetheless, then it must be an exercise of the Crown prerogative, which is still subject to judicial review under the same principles. And they rely on the Cotter decision, the Supreme Court of Canada, the 2010 decision, for that proposition. And we submit that the Cotter decision is heavily distinguishable and that the analogy to Crown prerogative is inapt in this circumstance. So the Cotter decision, of course, was when Mr. Cotter sought judicial review of the government's decision not to seek his repatriation from Guantanamo Bay. And he argued that this breached his rights under Section 7 of the Charter. And interestingly, actually, there's not a discussion, or at least an explicit discussion, of standard of review in that case. But if you read the decision, it's quite clear, actually, that the Supreme Court is employing a correctness standard in finding that the government breached Mr. Cotter's Section 7 rights by participating in the process at Guantanamo Bay. Certainly, we don't see the Supreme Court of Canada deferring to the decision of the minister, for example, that participating in the torture of a minor at an offshore detention facility was reasonable.
What was the path of that case? Where did it start?
Federal court. And then return to the federal court after the Supreme Court decision. But it was brought as a challenge of the government's, it was brought as a judicial review, but a judicial review of the Crown prerogative. But when discussing the constitutional issue, the breach of Section 7, it's quite clear that the court actually employs a correctness standard. But it's then in the discussion of remedy for the Section 7 breach that the Supreme Court goes into a discussion of the Crown prerogative over foreign affairs. But of course, that has nothing to do with the standard of review for whether Mr. Cotter's constitutional rights were breached. And so further, we say that the Crown's discretion in this case does not arise from the Crown prerogative. The source of the power of the authority to act arises from the treaty itself, from the solemn agreement of the parties. The treaty, which is itself a foundational constitutional document in this country. And in support of that, I would direct your attention to the Restool decision at paragraph 237. Again, tab 4, page 1288 of our compendium. And so this actually is in the context of the court's discussion of fiduciary duty. But the language at paragraph 237, I think, is helpful here. And I'm jumping down to, I'm going to start at the second sentence that starts the Aboriginal interest, where it says the Aboriginal interest is not the right to benefit economically from the land or the right to have the Crown administer certain land on behalf of the Huron and Superior plaintiffs. Rather, it is a right to receive a certain annuity and to have the Crown consider, and if appropriate, make discretionary increases to that annuity from time to time. And this is the important part. That right stems from the treaties and would not exist had the Crown not exercised its treaty-making powers to that effect. And so the point that I wish to make here is that the Crown authority to act derives from the mutual agreement of the equal treaty partners, of the nation-to-nation agreement. The parties came together and decided collectively to bestow that power on the Crown within certain constraints, of course, and that's much of what the rest of the Supreme Court decision is discussing. So it doesn't arise from statute or nor from the Crown prerogative, but from the treaty itself.
You use the words power and authority interchangeably.
In this context, I am. And so, in any event, even if you disagree with me and accept Ontario's argument that what the Crown is doing here is an exercise of Crown prerogative, well then the court in Cotter recognized that courts can review the exercise of Crown prerogative for compliance with the Constitution. And I won't pull it up, but at paragraph 37 of that decision, the Cotter decision, the court writes that it is for the courts to determine the legal and constitutional limits within which such decisions are to be taken. So I won't go there again, and of course then Mr. Schachter took you through the recent McKinnon decision, the 2025 federal court decision regarding the prorogation of Parliament. And there was a discussion in that case as well about the standard of review for exercises of the Crown prerogative. And in that case, the court says there are strong arguments in favor of a correctness standard here, but in any event, I don't really have to decide it because even if it's reasonableness, the only reasonable decision is to exercise the authority in compliance with the law and the Constitution. So the next analogy that I wanted to discuss is the duty to consult. And we say that that is completely inapplicable to this situation. And Ontario relies on the duty to consult jurisprudence and what it claims is a standard of reasonableness in such a context as a useful guide in this context. And that's, I'm quoting from Ontario at paragraph 115 of their argument. And I would urge this court to be cautious about drawing too heavily from the duty to consult jurisprudence in this context. So firstly, the Supreme Court did not refer to the engagement process as a consultation. Again, clearly the Supreme Court was familiar with the duty to consult and accommodate. They didn't use that language. They referred to a meaningful and honorable engagement process.
They also, I I just noticed from a reference that you brought up, or from a paragraph you brought up earlier, that they did use the word negotiation.
Yes, they directed the Crown to honorably engage and negotiate with the superior First Nations, but they did not call it consultation. And indeed, that's what our clients were seeking. We wanted to be engaged with, we wanted to negotiate. And I would also note that the duty to consult context is very different. The duty to consult and accommodate, it applies prospectively. Applies even when there's been no breach of an Aboriginal or treaty right, or no breach of the honor of the Crown. And in fact, it applies even in circumstances where the right, whether an Aboriginal right or a treaty right, is asserted but not yet proven. That is miles and miles away from what we're talking about here, where we have a treaty right that has been clearly established. No one disputes that whether the treaty right exists or not. And in fact, it's a treaty right that has already been egregiously breached for over a century. That is a very different context than the duty to consult. But again, in any event, even if you believe duty of consult is possibly relevant in this context, well then even in that context, the correctness standard applies to the Crown's assessment of the scope and the extent of that duty. And that actually, it does come from Haida Nation itself at paragraph 63, but the reference that I want to bring you to, because I think it explains this quite clearly, is a more recent decision of this court. That's the Attawapiskat decision. It's not in our compendium, so I'll give you the reference, and Ms. Angelova, I see, already has it up on the screen. It's 2022 ONSC 1196, Attawapiskat First Nation in Ontario. And at paragraph 45 of the decision specifically, the court writes, Crown decisions as to whether there are duties to consult or accommodate are reviewable on a standard of correctness. The Crown's assessments of the extent of these duties are generally questions of law, reviewable on a standard of correctness because they define legal duties. And they cite to Haida and a couple other authorities. And continues, thus, if the Crown misconceives the seriousness of a claim or the impact of infringement, this will be reviewable on a standard of correctness. And at paragraph 79 of the same decision, the court makes similar comments. So again, we say duty to consult doesn't apply. We're in a completely different context. But even if you wanted to draw on the teachings from the jurisprudence on the duty to consult, well, even then it's quite clear. When you're talking about the scope or the extent of the duty flowing from the honor of the Crown, correctness standard applies. So that's all that I wanted to say about standard of review. Barring any further questions, I'd move on to my next point, which is accounting for loss in the bring forward rate. The Crown exercise of discretion here is dishonorable for refusing to account for the losses they have inflicted on the Robinson Superior First Nations from their breach. We say that the honor of the Crown and reconciliatory justice requires the Crown to consider the losses that the Anishinaabe have suffered and attempt to remedy them. And this includes the lost opportunity from being deprived of the use of their rightful annuities for so long. So Ontario and Canada's approaches in this regard are slightly different, and I want to acknowledge that. So Ontario, for its part, explicitly makes the argument that considering the losses of the Anishinaabe is irrelevant to the analysis. And I'll take you to that reference. It's in Ontario's decision letter, which is at tab 3 of our compendium. And so at page 361, paragraph 53 of the decision letter. And the minister writes in that case, the Ontario disagrees with the position of the RSFN that compensation for past breaches of the augmentation clause must involve an assessment of quote unquote loss. At no point in Restool did the Supreme Court refer to an assessment of past losses as if the promise were to pay defined sums of money in the past. Rather, the Supreme Court refers to the present exercise of Crown discretion to compensate for past breaches. As the court held, the Crown must act now to respect the treaty promises to the Anishinaabe. That's Ontario saying we don't have to do an assessment of loss. That's irrelevant. Canada, on the other hand, does seem to accept that losses are relevant, but as we argue, they then refuse to actually reckon with those losses in the analysis, take them into account. And this is most clear in the approach of both Ontario and Canada to refuse to apply a bring forward rate, a present value rate, that actually accounts for the loss opportunity of the Anishinaabe.
At the end of the day, can you say, or because I'm worried if I have this wrong, but I don't think that identified a bring forward loss that they used, did they?
So they predominantly use the government bond rate. So Ontario is quite explicit. They say
that's what they said they took into consideration.
They applied the government bond rate to bring forward rates.
Found.
Ontario claims, well, we're only applying that. We're applying that to the benefits. We're not applying it to the losses because they say we actually don't have to assess what those losses are. We'll use it to bring forward the benefits. The result is the same at the end of the day. It's how the amounts are being brought forward. And Canada similarly says quite explicitly in their letter, we believe the most appropriate rate is the government bond rate. And they do, I will acknowledge, in one of these scenarios that the minister claims to consider, they also take into account the band trust account rate. But they do say the government bond rate is the appropriate rate or the most appropriate rate. And so my submissions on this topic, I'll cover two main points. Firstly, why the losses are relevant under both the Supreme Court decision and reconciliatory justice. And then secondly, the appropriate approach to measuring the loss. How do we actually measure that loss? So I will confess, I've gone back and forth on whether the losses suffered by the Anishinaabe should have been a sixth factor in the analysis. We talk about the 5 factors from the Supreme Court decision for compensation. Of course, the Supreme Court doesn't present it as an exhaustive list. They say the Crown and then, if necessary, the court must consider at least these 5 factors. So potentially losses could be conceived of as a sixth factor. Ultimately, we didn't pursue it as such in the engagement process. We didn't say, oh, losses should be a sixth factor. But that is because of how intimately connected it is to the existing factors, to the 5 factors. The needs of the Anishinaabe, the nature and severity of the breach, the honor of the Crown, we say all of those factors touch on overlap with this question of the losses. And so, quite importantly, the Supreme Court described the exercise that they sent off the parties to engage in as one of determining the appropriate amount of compensation. That term appears throughout the Supreme Court decision. And we submit that that term was not chosen by accident, and that term has specific meaning in the law. And whether under the common law or equity, compensation is about restoring the wronged party what they have lost because of the wrongful conduct of the other. And I'm not going to take you through those cases, but I'll just direct you to our factum, the factum of the Contingent Interest First Nations, paragraphs 60 through 62. And that's where we go through the case law, the jurisprudence on compensation. And that is what the Supreme Court ordered the Crown to do here, provide compensation. Particularly in the face of a long-standing and egregious breach of the treaty that had been unremedied for 174 years and stained the Crown's honor. Further guidance on this point comes again from the Supreme Court, but after it released its decision in Ristoul, and that is, of course, I'm referring to the Takuhikan case. I think Mr. Schachter referred to it as his favorite case of the week.
Favorite case of the day.
We'll see if it makes it to the end of the week. But it was in the Takuhikan decision where the Supreme Court introduces this concept of reconciliatory justice. And I think that that can provide guidance to us here as well, given that all parties accept that reconciliatory justice is the goal of the compensation here. And Ontario, in its explanation letter, it relies on the concept of reconciliatory justice to argue that it can disregard the losses. It actually takes this concept from Takuhikin and says, well, it means we don't have to focus on the losses or don't have to assess the losses because reconciliation is focused on the future and it's forward-looking. And we say that this is a profound misreading of the concept. Because as the Supreme Court explained in Takuhikin, reconciliatory justice has both a retrospective and a prospective application. And in fact, that is one of the key features that makes it different from corrective justice, is that it's not solely backward looking. And for this point, I will take you to paragraph 18, the Takuhikin decision, tab 5 of our compendium, page 1336. And I want to start slightly down the paragraph. I'll, of course, give Your Honor time to get there.
Got it. Thank you.
The second sentence in that paragraph, starting with rooted. Rooted in what might be described as reconciliatory justice, this remedy is not intended to compensate the Indigenous claimant only for harm suffered as a result of the past. It serves here, above all, to restore and improve the relationship between the Crown and Indigenous peoples in order to support reconciliation, a process that not only takes the past into account, but also continues beyond formal claims resolution. So the Supreme Court is explaining how reconciliatory justice has these two focuses. Not only compensating the Indigenous claimant for the past harms, but also restoring and improving the relationship. And we say, actually, both aspects of reconciliatory justice here require the Crown to consider the losses of the First Nations. The retrospective feature is perhaps more obvious. Considering the losses is necessary to compensate the Indigenous claimant for harm suffered as a result of past wrongs. But also, we say that fostering the relationship into the future, allowing the treaty partners to undertake future negotiations with equanimity, from paragraph 18 of Takuhikin again, requires the Crown to rebuild its trust with the First Nations. And rebuilding that trust can only happen if the First Nations see the Crown as truly reckoning with the damage that they have caused. That is what the chiefs and the councillor told the Crown during the engagement process. In order to move forward, we need to see you reckon with the past, correct the past, be accountable for what you have done to our communities, and then we can move forward. So the next point that I wanted to touch on in terms of why accounting for the losses is so important is the Anishinaabe principles behind the treaty promise. And what the Anishinaabe people were denied from the breach. But because the First Nations were not just denied augmented annuities in accordance with the treaty promise, in accordance with diligent implementation, but they were also denied what those annuities represented for their communities. And here I will take you back to the testimony of the chiefs and elders during the Stage 3 trial, where they explained that the augmentation promise was an ability for their people to continue to pursue Minobamadzuwen, or the good life, in the face of a changing world. They saw the augmentation promise as the ability for them to continue to meet the needs of their communities, both individually and collectively, as they welcomed newcomers onto their traditional territories, and their traditional ways of sustaining themselves were changing. And of course, you will remember how Minobamadzuwen was not just about subsistence survival, but it was about living the thriving life, the good life. And so when we talk about the nature and severity of the breach, when we talk about the long-standing and egregious breach, this is what the Anishinaabe people lost out on due to the dishonorable breach of the treaty. They lost the ability to use those augmented annuities for the benefit of their community, for Minobamadzuwen. And that leads us to the question of how does the Crown now account for and compensate for that loss? And we say it can be done through the method of calculating the present value of the unpaid annuities, which accounts for how the First Nations would have actually spent them. And I'm not asking for you to speculate. We didn't ask for the Crown to speculate on how the First Nations would have spent those augmented annuities, because we have evidence on that point. We have unchallenged evidence from the chiefs and elders from the Stage 3 trial. They told us, they told the court, they told the Crown how they would have used those annuities to invest in their community. Infrastructure, in housing, in healthcare, investing for the benefit of the next 7 generations. And again, I'm not going to recount all of that evidence. I'm not going to take the court through all of it again right now. And just for a brief summary of it, you can find that at paragraphs 91 to 92 of our factum. And that's actually why we say the 60-40 rate is appropriate to bring forward. And I want to be clear here. That is not because we are necessarily saying that the First Nations definitely would have invested in stocks and bonds in a mixed portfolio at this exact proportion. But rather, it is that the return rate on the 60-40 portfolio is the best method that we have to conservatively approximate the actual loss opportunity here. Out of all of the options that all the experts considered and presented, it does the best job. And the reason why I say that is because the return on investment for the types of spending that the First Nations would have actually engaged in, that human capital, social capital spending I just referred to, the rate of return on that spending is far higher than the 60-40 rate. And for that proposition, I'm relying on the evidence of Professor Stiglitz during the stage 3 trial. And we've included an excerpt of that at tab 8 of our compendium, page 1366. And that is, for the record, I can also say that's volume 6 of the transcripts. And specifically, I'm referring to pages 790 through to 792, tab 8 of the compendium. And so this was the cross-examination of Professor Stiglitz. And his answer here is included at page 790. He begins talking about investors with long-term horizons. And then he says, actually, I'm about halfway down the page, or just towards the bottom half of the page, line 15. Actually, what they would have done, given the level of deprivation, would have invested in infrastructure, education, health, and that would have yielded a far higher return.
Is that also presuming that the annuities would have been distributed to the bands collectively as opposed to individually?
Well, it was a collective right,
Yes.
right? The
But
Supreme Court has been.
I'm saying, but we know that it didn't happen.
We know that that didn't happen. Well, but the bands received, neither bands nor individuals ever received augmented annuities. They only received up to the $4 per person. So if we're looking retrospectively at what was the loss, what were they deprived of? What would they have done with the augmented annuities? We can't look retrospectively with the assumption that the Crown would have breached the treaty in a different way, with the assumption that the Crown would have acted dishonorably by paying the augmented annuities solely to individuals. And so I just read a portion of Professor Stiglitz's testimony, and of course, that's coming from an expert economist perspective, but it's consistent with what the chiefs and elders said. Given the deprivations in the community, these are the likely sources of where they would have spent the annuities, and they would have yielded far higher rates of return. And then Professor Stiglitz goes on, so as I explained in my testimony, the numbers here, I think, are very conservative relative to what the opportunity costs would have been if they could have actually had that money and invested it in providing for the community in jobs, infrastructure, education, and health. So these numbers, I believe, are too low. These numbers, he's referring to the rates of return on the 60-40 portfolio. And so just jumping down on the same page, to line 16, And what I'm saying is this is a lower bound on the opportunity cost. If that community had gotten together and had those resources, they would have done something that would have yielded a far higher return than I believe these numbers represent. They would have been able to invest in education and health and infrastructure and jobs. And the returns on that would have been much higher, and they would have been much better than even the numbers we put here would have said. And so that's why we say that the 60/40 rate is the most reasonable rate to conservatively estimate what the Anishinaabe lost by being deprived of diligent implementation of the treaty promise. And when considered that way, things like the risk premium in the stock market or the availability of access to the stock market in the 19th century, those are irrelevant.
The challenges to the concept of investing.
The challenges that Ontario and Canada have made about why the 60/40 rate is inappropriate. They refer to the risk premium, they refer to access to the stock market. Those objections are irrelevant when you consider the proper basis for using the 60/40 rate, which we submit is that it's a conservative estimate of what the Anishinaabe actually lost, of how they would have actually used those annuities. Now, these submissions may sound familiar to you. That's because this was our position on the bring forward rate in our closing submissions in stage 3, the stage 3 trial. Both in our written closing submissions, and I believe I stood up at this exact podium and made similar arguments. And we restated that position to the Crown in the engagement process. And specifically, that we did so on November 7th, 2024. And then we received the Crown's initial offers. Canada's offer on December 20th, and then the explanation for Ontario's offer came on December 27th. And there was nothing responding to this argument. Wasn't addressed, no explanation for why it was inappropriate. So, in the spirit of engagement for a reasonable treaty partner, we wrote back to both Canada and Ontario on January 6, 2025. And we said, you didn't address this argument. We pointed that out. We said, we've made this argument, you haven't addressed it. We cited back to the closing submissions of what was then the Group of 7 on this point. And I'm not going to take you there, but the language of our letter is included at our factum at paragraph 95. The letter that we sent on June 6th to say, hey, you didn't address this argument. We think you have to. And then we received the January 27th explanation letters.
I'm just turning it up, please. Thank you.
Then we received the January 27th explanation letters. And still, neither Canada nor Ontario directly addressed this argument. Completely absent. Addressed this argument, our argument on the 60/40 rate, that it was a conservative estimate of what the First Nations would have actually done with the funds, which would have yielded far higher returns. No explanation for why they rejected this argument or the uncontested evidence of the chiefs, elders, or Professor Stiglitz. So, despite raising this point repeatedly since 2013, including in our closing submissions at the Stage 3 trial and during the engagement process, the Crown has ignored us. And I ask, how can this be honorable and meaningful engagement?
You're saying crowns, in this case, plural, or crown?
Both.
Both.
The Crown, I've used the singular, referring to both Canada and Ontario. Both of them have ignored this argument. And we say that's not honorable, that's not meaningful engagement. It's not meaningful or honorable to completely ignore the evidence and positions put forward by your treaty partner. It's reminiscent of that historical pattern where the Anishinaabe had implored their treaty partner over and over to listen to them, to no avail. And even again, I spoke earlier about being wary to draw too much from the administrative law, case law, but even in administrative law, decisions can be quashed on judicial review if the decision maker fails to meaningfully grapple with evidence or submissions made by one of the parties. And in fact, the story does not end here, because we made this point again in our factum. And after that, I eagerly read through Canada's and Ontario's responding facta when I received them, hoping maybe there's finally a substantive response to this argument in there. But quite shockingly, they have still chosen not to address it. Instead, what you see in their facta are the same technical arguments about risk premiums and the availability of markets. And that's at paragraphs 82 to 84 of Canada's factum and paragraph 222 of Ontario's factum. Or I will add, Ontario also, of course, makes the assertion at paragraph 221 that losses are irrelevant to the analysis. And I've already explained why that's incorrect. And so in the coming days, when I sit down, my friends will get up to address you, and they may finally provide you with an answer, a response to this argument. And certainly my clients will be very interested in what they have to say. But frankly, it's too little too late at this point. Because the Crown's refusal to engage with this point has tarnished the engagement process and the exercise of discretion. And we would say, in fact, for this reason alone, the exercise of discretion should be set aside. But of course, there are many other reasons why we say it must be set aside as well. And so just before leaving this point about the rates of return on human capital and Professor Stiglitz's testimony, I wanted to address a question that you had asked Mr. Schachter about any evidence from the Stage 3 trial contesting Professor Stiglitz's evidence that the rate of return on these human capital investments was far higher. And that is, of course, far higher than even the 60-40. And so I have a number of responses on that point. Firstly, neither Canada nor Ontario challenged Professor Stiglitz on this point in cross-examination. They could have done so, they chose not to. None of Ontario's experts expressly challenged this evidence. They were focused on justifying the government bond rate, their preferred rate, and also attacking the 60-40 rate. There was much evidence from them attacking why 60-40 was inappropriate, but they never actually addressed Professor Stiglitz's claim that, in fact, the human capital investments would be far higher than 60-40. And so, as Mr. Schachter explained, Professors Booth and Kersner, who were Canada's experts, they provided, you may recall, a model for bring forward rates that had different components with different rates assigned to those different components. Some of those components would be what we would put in the bucket of human capital, social capital investments. And there was a dispute between the experts on the exact rates to be used. And I think there was some dispute on the appropriate role for depreciation to be used there. But as Mr. Schachter took you through already, essentially what this dispute boiled down to was how much higher are the rates of return on human capital versus the 60-40 portfolio. Which again, that doesn't change the core of our point, which is that the 60-40 portfolio rate is a conservative underestimate of the actual loss. And in any event, Canada is not relying on the model from Professors Booth and Kersner. I can't recall precisely in this moment if they relied on it in their closing submissions in the stage 3 trial, but certainly in the exercise of discretion, Canada has not sought to rely on the Booth and Kersner model at all. But I'll take a step back though as well to note that there is a more fundamental issue though, which is, as I noted, neither Canada nor Ontario engaged with this point in the engagement process, in the negotiation process. They could have challenged Professor Stiglitz's evidence in that context. They could have proposed other rates that they believed were more reasonable for these types of human capital investments. And we could have had a discussion. We could have had a back and forth. Maybe there was an agreement to be reached, a compromise to be reached. Okay, we think that these rates of return that you've proposed for human capital make sense. We're happy to work with those rates. But they didn't do that, so we couldn't have had that engagement. And so for that reason, I submit that it would not be honorable for them now to come and say, well, Professor Stiglitz was wrong about the human capital rate of return being far higher than the 60-40 rate. So barring any further questions on accounting for loss and the bring forward rate, I would actually propose to move on to my final portion of my section, which is the contingent interest shares. So as this court is well aware, my clients, the Contingent Interest First Nations, have their ongoing title cases where they are disputing that they are parties to the treaty. And the terms of our involvement in this case included that this court would not determine their status under the treaty, and we're not asking you to do so. The separate process for the title claims must be allowed to play out in its appropriate forum. But that raises the question of, well, what do we do with the share of compensation that my clients have their contingent interest in? And that's both their contingent share of the $3.6 billion. But also, of course, if this court were to order additional amounts or order the Crown to provide additional amounts, then we would need to consider what to do with our contingent share of those amounts as well. And the proposal here would be the same either way. And in general, the discussion here, I think, is guided by two fundamental principles, which we say that the court should have in mind when considering the appropriate terms for the contingent interest shares. Firstly, ensure that the share is secure and available to be collected promptly when each of my clients becomes entitled to it, if and when they become entitled to it. And secondly, that its present value is protected. And that's because, of course, we are talking about a significant amount of money here. And my clients do not want to be prejudiced by any delay in resolving the title cases. Because, of course, they're not entirely in control of the speed, the progress of their title cases. So if those take time to fully resolve, they don't want to be prejudiced by the amount of time that has passed before they can collect their share. We had proposed various terms, both in the context of the engagement process, and those are the same terms that we're proposing to the court now. I will say many are not in dispute. I think actually I agree with my friends on most of the terms. There is one that is a bit more contentious, and I will get there. Firstly, we would ask this court to declare our interest in the contingent shares.
By nation?
Yes, and there's agreed upon percentages. We're not seeking to challenge that now. Those agreed upon percentages were the terms of our intervention order. We've set it out again in our factum that can be easily converted into precise dollar amounts.
Okay.
But then, of course, similarly, if this court were to order additional amounts, then we would ask for a declaration of our interest in those amounts as well, according to the same shares.
And in your factum, can you direct me to the paragraph? Do you do the calculation? The percentage share?
We provide the percentages at paragraph 250, we provide the percentages.
Yes, I see.
We have not provided the precise dollar amount. I believe we actually have provided that to my friends, but certainly we can provide that to the court, either in this context or in the context of agreeing upon the form and content of the precise orders. That can certainly be done. That's just a matter of math. It shouldn't be contentious. I say just a matter of math. Secondly, would be that the terms of the order would be that the amounts will be distributed on further order of the court. And I don't think there's anything contentious there. That my clients may bring a motion for the distribution of its share when it wishes. And important.
Is it presumed, I'm just going back to something you said earlier. They're involved in their own processes. I presume what you're saying is they're each involved in their own processes, or are they jointly involved in that?
Yes and no. There are separate title cases for each of the Contingent Interest First Nations. They are being case managed together. They have not been formally joined. They are 6 distinct title cases, but they are being case managed together. In fact, 5 were put in abeyance pending a trial of an issue in one of the cases, and then they're now all in abeyance pending negotiations. So that actually does lead me to the next term.
So that question was, is it conceivable that nations might bring under 3, First Nations may bring a motion for distribution of its share when it wishes, that may be on a nation by nation basis.
Absolutely. And in fact, that is actually the fourth point,
Okay.
is that the shares don't have to be dispersed all at once. So if one of the six is prepared to collect their share, they may do so even if the other five are not there yet.
And do the other, if one of five arrives on a motion for distribution, do they have to have the consent of the others?
I don't think that would be necessary if it's just the share if it's just one of the six asking for its own share.
In the amount already.
The amount will already be set out.
Percentage set out in an order from this card.
If for some reason one of the other five would want to raise an objection, for some reason, I imagine they could, and there may be an issue of standing at that point. But that I don't think is something that needs to be determined at this point. But
that's what you mean by four.
yeah, so for example, so AZA was in the group of seven group. They in the process since the stage 3 trial, they resolved their land claim with the Crown, and they've moved from the Contingent Interest First Nation group to the treaty beneficiary group, and they are in the process of collecting their share. So similarly, if one of the six who are still the Contingent Interest First Nations, if they're ready to collect their share, they can come and do so. They don't have to wait for the other five to be ready as well.
And are one of the terms where who's controlling this money? Where are they going for?
So we're content with a declaration of the court.
Okay.
So we're not asking for the court to hold the money or invest the money on behalf of my clients or anything like that. Where it's a declaration against the Crown, we're content with a declaration against the Crown. And so I will note here as well in this discussion that we're having about different First Nations bringing a motion to collect their share. So for example, some of the Contingent Interest First Nations may wish to bring a motion to collect their share or have their share distributed to them before the resolution of the title claim. And they might make an argument that, well, this money should be ours in any event, because either we're entitled to it as annuities or we're entitled to it as compensation for loss of use for unextinguished Aboriginal title. But that's not a matter for today. That would be arguments to be made in the context of those motions.
Okay, good.
And so those terms that I've just gone through, I believe that those are the non-contentious ones. I don't see the Crown, either Canada or Ontario, taking particular issue with any of those, but of course, happy to hear from them and reply if necessary. The parties also, or at least I believe, all appear to agree that the present value should be protected in some way, but the dispute is how best to do that. And our proposal is to use the post-judgment interest rate under the Courts of Justice Act. To be clear, we're not arguing that Section 129 of the Courts of Justice Act strictly applies in this context, but rather we've proposed it as a reasonable and a practical solution in the interests of reconciliatory justice in these particular circumstances. So Canada, in their factum, doesn't respond directly to our submissions on this point about the appropriate interest rate. At paragraph 139, they include some terms for the contingent interest share. Those terms, proposed terms for Canada, are silent on the interest rate. So certainly they've made no argument that our proposed rate is inappropriate for any way. And they don't propose any alternative that they say is consistent with the honor of the Crown or reconciliation. Ontario, for its part, its primary argument seems to be that this is not the forum for resolving the question of the appropriate interest rate. That's at paragraph 293 of Ontario's factum. But they then don't go on to suggest what the appropriate forum would be. So I'm not sure where they would like my clients to go to resolve this issue. We did raise this issue during the engagement process, and the parties were not able to resolve it in that forum. So that is why my clients have come to this court. And on principle, we say that the question of interest should not be deferred to when each First Nation seeks to collect its share. And we say that for a number of reasons that I'll take you through. Firstly, it creates uncertainty. And that in and of itself is an issue. Secondly, it creates a real risk of future contentious litigation.
Is all litigation not contentious?
Well, I think there is a real possibility that the motion to collect the share might be a simple consent order. For example, if there is a resolution, for example, a negotiated settlement in the title claim for one of the communities, and that settlement involves either a recognition that the First Nation is a party to the treaty or an adhesion to the treaty, for example, then they may come to a point where the Crown, the First Nation, they all agree, okay, yes, we are now a party to the Robinson Superior Treaty. We're entitled to that share. Let's go to the court and collect and get that order to collect our share. Ideally, that would be a very simple matter, a simple consent order. If it's then, well, we now need to determine what the appropriate interest rate is to pay to your share, that converts what might otherwise be a simple motion into something that is very contentious. And we would say that's inconsistent with reconciliatory justice and fostering the treaty relationship to consign these parties to that contentious litigation. And of course, inconsistent with the direction that we've heard from the Supreme Court on a number of occasions to that reconciliation should take place outside of the courtroom where possible. The third issue is the risk of inconsistent results. So we already spoke about different First Nations collecting their shares at different times. Well, if that happens, then different courts may order different interest rates. Or, in order to protect themselves against that happening and protecting themselves against an adverse precedent, well, all of the First Nations would need to ensure that they are present in making submissions on the interest rate whenever the first of them is ready to go. And that we submit that's just a messy situation that this court should not be creating for the future. The fourth point is the improper pressure on the title cases. It could create pressure to settle the title cases quickly to avoid this risk, this uncertainty. The risk that, well, if we don't move quickly and settle our title cases, then we're not going to be adequately compensated for our share of annuities. And the reverse of that, or the other side of that coin, is potentially an incentive on the part of the Crown to delay resolution of the title cases. So lastly, I'll deal with Ontario's alternative argument or as I believe I read it as an alternative argument, that pre-judgment interest, not post-judgment interest, should be appropriate. And Ontario's position here seems to be based on the incorrect proposition that post-judgment interest is punitive and that it's meant to disincentivize a defendant from delaying payment. And in fact, that's not true. The courts have been clear that the post-judgment interest rate is not punitive, and its goal is simply to ensure that the plaintiff is fully compensated for their loss and is made whole. And for that proposition, I would take you to the Apotex decision, federal court decision, at tab 10 of our compendium. And at paragraph 122, the court writes that more precisely, pre-judgment and post-judgment interests serve a twofold purpose. It compensates the plaintiff for the cost of the money claimed, and it deprives the wrongdoer of a windfall benefit he would otherwise receive. And then at paragraph 123, about halfway through the paragraph.
Sorry, is this in your compendium?
It is at tab 10.
Thank you.
At 123, about
I have a few paragraphs.
122 to 123. I'm at 123 now.
Thank you.
And the court says, in either case, however, I would adopt the long-standing principle in the Anglo-Canadian jurisprudence that interest should be used neither as penalty nor reward, but should stand as part of an award to make the aggrieved party whole. I'll just address for Ontario's proposition for against the post-judgment interest rate. They cite the Pelishok and Pelishok decision, which is at tab 11 of our compendium. And specifically at paragraph 34 of that decision, Justice Lowers, as he then was, cites from Morden and Perel, the law of civil procedure. And I'm just going to the quote that is included at paragraph 34. And about halfway through the paragraph, awards of prejudgment. And the court says, or the quoting from the authors, awards of prejudgment and post-judgment interest are designed to take the advantage of delaying payment away from the debtor, to encourage the early payment of debts, to encourage early settlements, and to discourage defendants resisting payment simply because of the financial advantage of delaying judgment. And my point here is simply that this proposition that Ontario cites just refers to the general principles behind both pre-judgment interest and post-judgment interest. So it tells us nothing about why one would be more appropriate than the other. It's not a valid objection to our argument that post-judgment interest should be used.
When you say it doesn't tell us why one would be more appropriate than the other, it doesn't tell us why pre-judgment would be more appropriate.
Yes, because Ontario makes the argument, it can't be post-judgment interest, it has to be pre-judgment interest. And then they cite to paragraph 34 of the Pelishok decision. And so given that we are discussing an interest rate on an amount identified in an order of this court, we propose that it's consistent with the standard practice to apply the post-judgment interest rate, and that is consistent, principled, it's a reasonable compromise in the interests of reconciliatory justice here. to achieve our goal of protecting the present value of the contingent share until each of my clients, if and when they're ready to collect it.
Thank you.
And so barring any further questions, that brings me to the end of my section of the argument. Given the time, I think it makes sense for us to take the afternoon break, and then Ms. Angelova will be up.
Thank you. Let me catch up. Okay, let's take a break. 15 minutes.
Score is to down for 15 minutes. Score is resumed. Please be seated.
Ms. Angelova.
Good afternoon, Justice Hennessy. My name is Geri Angelova, and as my co-counsel, Mr. Bass, alluded to, I am one of the counsel that represents the Contingent Interest First Nations. And I'll be addressing two issues before you today. First, that the Crown has not adequately compensated the First Nations for the years 2020 to 2025. Canada has unilaterally assigned an arbitrary amount to compensate for this time period with no contemporary evidentiary basis. And Ontario has provided no compensation at all for this period, assigning no resource revenue and not applying any interest up to 2025 to its exercise of discretion. Second, the Crown has failed to properly consider the needs of the Superior Anishinaabe. Both Canada and Ontario have limited their exercise of discretion to largely focus only on the present needs, disregarding the deep and long-standing unmet needs of the last 7 generations of Superior Anishinaabe who lived impoverished lives and died under a broken treaty promise. Turning now to the first issue, the Crown's failure to adequately compensate the First Nations for 2020 to 2025. The Contingent Interest First Nations written submissions on this issue can be found at our factum, beginning at paragraph 201. I'd like to begin by providing some background on the engagement process to situate this issue for the court. During the first in-person engagement session between the First Nations and the Crown on September 19th, 2024, the First Nations proposed a series of foundational principles that we hoped would help guide the parties in their discussions. The first foundational principle to rebuilding the nation-to-nation treaty relationship that the First Nations emphasized was their commitment to a transparent, predictable, and rational process in the assessment of past compensation. And I won't take you to them now, but for your reference, there are comments to this effect made in the letter from the First Nations dated August 19th, 2024, which sets out our vision of the process for renewing the Robinson Superior Treaty relationship. This letter can be found in the record at tab 5. And the specific reference I would point you to is at page 1155. We once again raised these foundational principles, including our
Are
commitment.
you taking me to tab 5 or just telling me where it is?
I wasn't planning on walking you through the contents of the letter, but just to give you a sense of the commitment we were hoping to achieve with the Crown.
Sorry, I interrupted you. Go ahead.
Not a problem. The same notion was expressed again at our meeting on September 19th, and the meeting minutes for that session can be found at tab 92 of the record. So throughout the engagement process, the First Nations repeatedly emphasized the importance of an evidence-based approach to implementing all 5 factors set out by the Supreme Court of Canada in determining a just, liberal, and honorable amount of past compensation. And it is in this spirit that all of the parties agreed that the Stage 3 record will form an integral part of the engagement process, and that it would provide the basis for the transparent, evidence-based approach to assessing past compensation. And I would just note that this is consistent with what the Supreme Court of Canada had envisioned at paragraph 310 of the Ristool decision. Where-
Are you saying the parties did agree that Stage 3 record would form an integral part of an engagement process, or that you were proposing this?
All parties did agree that the Stage 3 record would form the key body of evidence that would then perhaps be supplemented, but we were all going to be grounded in the Stage 3 evidence, as that was the most reliable trial-tested evidence available for the parties at the time.
Thank you.
And the Supreme Court of Canada also indicated that the parties could rely on the Stage 3 evidence already adduced before Your Honor to inform the court's review of the Crown's exercise of discretion. And we find that authority at paragraph 310 of the Ristool decision. So with this context, it is for that reason that the First Nations requested that the Crown should calculate past compensation based on this available trial-tested evidence that only goes up to December 31st, 2019. This request was made repeatedly, but one point of reference that I can direct Your Honor to can be found at tab 99 of the record. These were the meeting minutes from the October 9th engagement session. From the First Nations perspective, this was not a controversial request, given that the limited data that was before the court during the Stage 3 trial. The First Nations understanding at that time, during the engagement process, was that any discussions about augmentations beyond 2019 would be addressed as part of future annuities.
Was this an understanding that they maintained throughout the engagement process?
Throughout the engagement process, given the Crown's inability to engage with us in terms of providing concrete positions on certain positions that the First Nations had taken, we hedged our bets, so to speak, and asked that whatever approach the Crown does apply, they at least apply the bring forward rate up to the present. So we would like an accounting of any resource revenues during this period, but any period of time beyond 2019 should incorporate that accounting as well. Perhaps I could address it alternatively. Any bring forward rate that the Crown would apply would have to account for that period of resource revenues.
But any bring forward rate would have to apply to that period of revenues.
Correct.
Is that what you're saying? But I was working on your understanding through the engagement process. You wanted it, you wanted the revenues only to be examined as consistent with the trial evidence, which ended in December 2019. You sought that agreement, but you didn't receive it. So when you talked about bring forward rates, you hedged your bets.
Right. So I guess to clarify, the First Nations position has consistently been an evidence-based approach. So from the First Nations perspective, it almost went without saying that any annuity beyond 2019 would require further evidence to be considered. That evidence was not provided. So the presumption from the perspective of the First Nations was that the relevant timeframe for addressing past compensation would run from 1850 to the end of 2019. The Crown did not provide any concrete agreement or refusal to apply this principle. We were somewhat left in the dark, but our assumption was that this would be the approach the Crown would take in light of our agreement that the stage 3 evidence would be determinative on the issues of calculating resource revenues.
Oh, is it fair to say, because I'm starting with what you understood, is it fair to say you understood there was an agreement that you would be relying on evidence, but you weren't confident the Crown bought into that?
Right, that's a fair way of characterizing it. Thank you for helping me with that. So effectively, it was really not until the initial offers came in from the Crown on December 20th, we received the offer from Canada, and on December 27th, we received the offer from Ontario. And in Canada's offer, this is the first time where Canada formally advised the First Nations that its methodology would compensate from 1850 to December 31st, 2024.
And which of the January letters was this? Was this their final letter?
This was the initial settlement offer that was provided on December 20th,
December
2024. And for your record, it can be found at tab 46. And this exact reference where they referred to the December 31st, 2024 cutoff date can be found at page 2985 of the record.
Thank you.
And so Ontario delivered its reasons for its settlement offer that was made back in December 2024. Those reasons were provided on December 27th. And they also defined the relevant time frame as 1850 to quote unquote the present, without assigning a concrete date to that assertion. Now at paragraph 148 of Ontario's argument, it clarifies that this reference to the present refers to the date of the Crown's exercise of discretion, namely January 27th, 2025. We say that this unilateral imposition of the relevant time frame does not reflect the conduct of an honorable treaty partner. It is yet another example of the Crown superimposing its preferred approach over the express wishes of the First Nations, trumping their voices at the 11th hour in a way that frustrates the nation-to-nation treaty relationship and the engagement process that the Supreme Court of Canada directed. So despite the Crown's expressed commitment to a transparent, predictable, and evidence-based assessment of past compensation, the Crown's purported exercise of discretion to the present, which I might add Canada and Ontario define slightly differently, is untethered to that stage 3 trial tested evidence. If the Crown had a genuine intention to compensate the First Nations up to the present, it was within the Crown's prerogative to provide the data on resource revenues from 2020 to 2025. This would have enabled a collaborative, nation-to-nation dialogue on how to determine the amount of compensation for this period. But this evidence was not provided over the course of the 6-month engagement process, despite it being fully within the Crown's power to share. So, in the absence of this data, Canada goes on to estimate the approximate amount of compensation for 2020 to 2025 by extrapolating a, bless you, by extrapolating a $23.8 million average based on the net Crown resource revenues from the 5 years prior, so from 2014 to 2019. And this is how Canada comes up with its $120 million figure to compensate the First Nations for this time period. Canada unilaterally adopted this methodology without engaging the First Nations or seeking input from the Stage 3 trial experts. As the Contingent Interest First Nations point out at paragraph 204 of our factum, Mr. Hutchings could not provide new calculations for this period precisely because the Crown failed to provide the underlying data. So the numbers we currently have from Mr. Hutchings are the numbers that go up to the end of 2019 that have just been brought forward to the present time. The fundamental issue with this approach is that it is arbitrary. It is completely divorced from any actual evidence.
So if I understand this right, when you say Mr. Hutchings' number is using the data up to 2019 and applying the bring forward rate.
That is correct.
So presuming zero.
Presuming that there are no additional resource revenues for this time period, not taking account of any potential.
Okay, not taking account of any, but Canada presumed 23.8 million.
As an average per year for a 5-year period,
As an
amounting.
23.8, and their bring forward rate would have been applied to that extra. So that's like 115 million more in nominal values, 5 times 23.8.
So not quite, and I apologize if I wasn't clear. So this $23.8 million average is the annual average for the period from 2014 to 2019. And when we multiply that by 5 to get the 5-year amount, we're at 120 million. based on my reading of Canada's reasons, it's unclear to me how that amount is factored into its total amount of past compensation or the interest rate that was attributed to it. But as I take it, Canada's reasons indicate that 120 million would apply without accounting for the interest rate for that period. And I'm sure my friends will correct me if I'm mistaken.
Thank you.
At Canada's factum, in paragraph 81, Canada claims that it took this approach so that the First Nations do not have to wait any longer. And they make a similar justification in their decision letter, where they say that they reached this unilateral decision on the appropriate time frame so that future annuity discussions could focus on the future. This explanation, to avoid further delay, simply rings hollow. If the Crown was truly concerned about making the First Nations wait longer to receive compensation for this period, they could have promptly provided the data and enable early engagement on it.
Oh, you said it was Canada who said this.
Canada did say this, and we understand that there is an issue with having two crowns that are the keepers of different sets of data. This is
You're questioning their motive.
when I speak in terms of the Crown, like my co-counsel, Mr. Bass, I'm referring to the Crown singular to refer to both Canada and Ontario. And neither Canada or Ontario even raised this issue of bringing forward new evidence so that resource revenues for this period could be calculated. It simply never came up. If it was Canada's intention to compensate to the present, it ought to have raised the evidence that it proposed to do so with.
You're saying you had no, First Nations had no notice that Canada had a plan.
Prior to December 20th, no, we did not.
Thank you.
So this delay was ultimately within the control of the Crown. Ontario's approach is even more troubling. While Canada's extrapolated figures are flawed and untested, Canada at least tried. Ontario, on the other hand, provided nothing at all for this 5-year period. Ontario does not offer any data, analysis, estimation for Crown benefits between 2020 and 2025. All of Ontario's calculations of net Crown resource revenues, along with the related adjustments in its decision letter, are based solely on the Stage 3 trial evidence, which does not extend beyond 2019.
Is this consistent with their position that there would be no net Crown revenues?
And I thought about this point after Mr. Schachter raised it in his submissions the other day, but nowhere in Ontario's decision letter does it say that this is why no compensation was attributed for this time period. So while Mr. Schachter suggests that that may be one of the reasons, the First Nations are simply left to guess. And more importantly, there is no way for the First Nations to verify whether there was in fact no Crown benefits during this time period. We don't have the underlying data. So what we're left with is Ontario assigning no revenues at all for the years after 2019 with no explanation, let alone preserve the time value of that money. And yet, Ontario claims to have now fulfilled its obligations under the treaty up to January 27th, 2025. The result being that under Ontario's approach, the years 2020 to 2025 will forever be excluded from the treaty promise. Ontario's assertion that it has honorably compensated the First Nations up to the present is yet another empty shell of a treaty promise, considering that Ontario has effectively given itself a free pass for the past 5 years.
When you say that whatever Crown benefits there are for that 5-year period are forever excluded, I presume you're also saying that that data is forever excluded. Or that, another question is, it's a corollary question, is that when Ontario says they have fulfilled their obligations up to 2025, do you say that they're saying they have fulfilled their obligations to supply information?
No, we do not say that they fulfilled their obligations to provide the data. For one reason or another, Ontario does not seem to think it necessary to provide the data, but it is in order for the treaty parties to engage meaningfully in future annuity augmentations. It's entirely uncertain from the perspective of the First Nations whether they were adequately compensated up until the present, whether that is defined as December 31st, 2024, or January 27th, 2025, when the data that these determinations are based on only go up to 2019. And so these divergent approaches taken by Canada and Ontario that contradict the express wishes of the First Nations must be resolved by this court to fix the fundamental uncertainty regarding whether the First Nations have in fact been fairly compensated for the ongoing treaty breaches after 2019. The uncertainty would otherwise risk undermining the integrity of these future annuity augmentations and present significant barriers to the treaty parties' ability to repair the relationship on a go-forward basis. Subject to any further questions on that issue, I now intend to turn to the Crown's treatment of the needs of the Superior Anishinaabe. And our written arguments on this issue can be found at paragraphs 102 to 143 of the Contingent Interest First Nations Factum. I will be making 3 arguments on this point. First, that the Crown, and by the Crown, I mean both Canada and Ontario, takes an improperly narrow approach to considering needs, one that is only focused on the present needs of the Superior Anishinaabe. Second, I will highlight how this approach is inconsistent with the purpose of the treaty and the Anishinaabe perspective on the aim of the augmentation clause. Third, The Crown's failure to account for the full extent of needs of the Superior Anishinaabe, while simultaneously invoking broader colonial harms and other discretionary funding to diminish the amount of past compensation owed, is fundamentally incongruent with the honor of the Crown. Bringing it back to the engagement process, the First Nations consistently expressed how an honorable treaty partner ought to consider the needs of the Superior Anishinaabe, and that any exercise of Crown discretion must take full account of the needs, not only today, but over the entire 175-year period of treaty breach. That is what the duty of diligent implementation requires. This position was clearly articulated by the First Nations in correspondence dated November 1st, 2024. This can be found at tab 29 of the record at page 2016. And there,
Just going to ask you to let me catch up for a moment, please.
of course,
Tab 29 of the record.
right, that's at page 2016.
Which I will not find in your compendium.
It's just the overall point that I'd like to make. It's
You're
not.
just telling me where it is. Thank you. Go ahead.
There, the First Nations emphasized that the treaty relationship is not merely a one-time financial transaction, but an ongoing relationship with the Anishinaabe based on the values of respect, responsibility, reciprocity, and renewal. The Crown was asked to reciprocate this understanding and incorporate it into its assessment of compensation, but it did not. Despite repeated requests to reckon with the long-standing history of unmet needs, Canada and Ontario have adopted an artificially narrow understanding of needs as being limited to the present. They both do so in slightly different ways, so I'll discuss Canada and Ontario respectively in turn. Canada acknowledges that the needs of the Superior Anishinaabe are great, and that these communities do not enjoy the same level of well-being as their Indigenous and non-Indigenous neighbors. However, even Canada's reference to this undisputed fact only addresses the present-day needs of Superior Anishinaabe. Its assessment is based on present-day populations. At page 21 of its decision letter, Canada does reference that compensation must address intergenerational harm caused by its long-standing treaty breaches. But then, Canada maintains that this will be achieved by bringing forward the value of the unpaid annuity augmentation, and goes on to adopt the government bond rate to do so. We submit that by invoking the government bond rate as a means to redress intergenerational harm over the past 175 years, Canada trivializes the magnitude of the unmet needs over the past nearly 2 centuries. Canada provides no meaningful explanation as to how the government bond rate could possibly account for generations of unmet needs in the past, or even how it could help close the immense income gap between the Superior Anishinaabe and other surrounding communities today. As we point out in our factum, Canada's preferred rate, the government bond rate, cannot actually account for these needs, because what it really does is measure the benefits accrued to the Crown as a result of its long-standing breach. This does not correlate to the needs of the Anishinaabe in any way. Ontario, for its part, is even more brazen in its disregard for the past needs of the Superior Anishinaabe. At paragraph 34 of Ontario's decision letter, Ontario states that the Crown is required to consider present needs in respect of, and I quote, regular augmentation decisions. But this cannot be a regular augmentation decision. It is a constitutional reckoning of over a century and a half of broken treaty promises, where the Supreme Court of Canada has directed the Crown to exercise its discretion and increase the annuities. It is a result of long-standing and egregious breaches of the Superior Anishinaabes' constitutionally protected treaty rights. This exercise of Crown discretion is not regular. It is meant to redress the totality of these past breaches and not just consider present conditions like any other exercise of Crown discretion would on a go-forward basis. Ontario also relies on the grammatical tense used in paragraph 309 of the Supreme Court's decision, arguing that because the paragraph speaks in present tense, it only authorizes consideration of the needs of the living. But we say that this is a superficial, technical, and ultimately untenable reading of the Supreme Court of Canada's decision. It is unsupported and unnecessary parsing of individual words in a lengthy decision to take ambiguous language at most to support the Crown's preferred view of compensation.
Is it possible for you to take me to paragraph 309?
I will turn to my co-counsel, Mr. Bass, and see if he would be able to pull up the Supreme Court of Canada's decision quickly for me.
Are you online? Spencer? Over there?
Could you zoom in a bit on that, please? Thank you. And it's subparagraph B in 309 that you say Ontario is referencing.
And takes a technical parsing of to support its preferred interpretation of how this need factor should be considered as being limited to the present tense. But nowhere in the Supreme Court of Canada decision does the court expressly limit the consideration of need to present needs. This has been referred to as a long-standing and egregious breach. And to insist otherwise would be to simply disregard the generations of individuals who have lived and died under a treaty promise without ever receiving their share of the wealth in the land in exchange for their most precious gift to the Crown. And that, in our submission, would be dishonorable. And more importantly, irrespective of this parsing of the grammatical tense in the Supreme Court of Canada's decision, the decision itself must be interpreted in light of its overarching goal in its remedial direction. And that goal is to restore the honor of the Crown and to ensure that the Anishinaabe receive fair compensation for the Crown's breaches of the treaty. We anticipate that Ontario may point to other aspects of its analysis where it does purport to consider intergenerational harm. And we see this in Ontario's discussion about Factor 1, the nature and severity of the breach, and under Factor 5, the honor of the Crown. But once again, these references to intergenerational harms only really account for the past unmet needs of the Anishinaabe that manifest themselves today. That is not the same as taking into account the unmet needs, the generations of Anishinaabe peoples who lived and died under a treaty promise that was never fulfilled in their lifetime. More fundamentally, Ontario does nothing to explain how simply paying lip service to these deep and profound intergenerational harms actually changes or impacts the result of its assessment to past compensation. We simply don't know. Ontario does not tell us. In effect, the Crown has treated the consideration of needs as a snapshot in time, rather than what it truly is. And that is a lens for understanding the cumulative, long-term, compounded impacts of its 175 years of treaty breach and deprivation. The Crown's presentist approach is also fundamentally inconsistent with Anishinaabe legal principles and the underlying foundation of the treaty relationship. As the Supreme Court of Canada held at paragraph 3 in Restool, restoring the honor of the Crown requires returning to the foundations of the treaty relationship between the Anishinaabe and the Crown. Those foundations lie in the Covenant Chain Alliance and the Anishinaabe legal principles of respect, responsibility, reciprocity, and renewal. The Anishinaabes' understanding of the treaty relationship was never purely economic. It was relational. It was a nation-to-nation agreement rooted in kinship, reciprocity, and the duty to provide and care for one another. In this sense, the Crown was understood to be the Great Father or the Great Mother, which was a figure of responsibility and not authority, one that cared for the needs of its children. This understanding of the nation-to-nation treaty relationship is also well illustrated by the Covenant Chain Alliance, which was symbolized by a ship tied to a tree, first with a rope and then with an iron chain. And as you will recall, Justice Hennessy, the rope represented the alliance of equals and the iron represented strength. And the idea behind this analogy was simple, that if one party was ever in need, all they would need to do is tug on the rope and give the signal that something was amiss, and all would be restored. At paragraph 286 of the Restule decision, the Supreme Court recognized that the Anishinaabe treaty partners have been tugging on this rope for some 150 years now, but the Crown has actively ignored their calls. The Supreme Court went on to say and warn at paragraph 291 that the Crown cannot be allowed to continue to undermine the very object and purpose of the treaty promise. Yet by adopting artificially narrow and self-serving interpretations of need, the Crown has done exactly that. To let the Crown now claim that it need only consider the needs of the present generation would allow it to benefit from the longevity of its dishonorable conduct. Had the Crown honored its duty of diligent implementation from the outset of the treaty relationship, it would have had to revisit the annuity many times over and account for changing economic conditions and growing needs over generations. And so, just for argument's sake, in 1925, when Canada was entering a period of economic modernization, an honorable Crown, acting with diligence, would have assessed whether these developments were generating wealth from the treaty territory that triggered the augmentation clause. It would have looked at the changing costs of living and the needs of the Anishinaabe. And it would have taken steps, if there was wealth from the land to be shared, to augment the annuity to reflect a share that would be commensurate or appropriate to address the growing needs of its treaty partner, to ensure that they continue to grow and advance together.
I might need you to help me out here. So there were needs long before 2024 or 2020. And those needs were unmet when the annuities were not paid. So let's say the goal, let's say it was achieved. I think these are called thought experiments. Let's say the annuities were calculated in a way that the treaty partners, the Anishinaabe treaty partner was satisfied, was a reasonable share of the the full benefits the Crown received.
Mhm.
And let's say that to those benefits was attached a bring forward rate, which the Anishinaabe partner was satisfied with. Would you still say there were past harms unmet? Or are the past harms met by an honorable calculation of past benefits brought forward at a rate that is agreeable to them.
Partially. The other aspect that would account for the unmet needs would be a commensurate share. So
So if the share was if the Anishinaabe partners were content with the amount of benefits, content with the share, content with the bring forward rate, would there be something left other than deterrence, vindication, punitive? Would there be something left for harms? That were
Beyond-
unmet harms?
I understand the question now. Yes, so beyond any sort of additional deterrence, vindication damages, that would adequately account. An appropriate bring forward rate that addresses the unchallenged evidence that we have from the stage 3 record would adequately compensate for the past unmet years.
And the reason I ask that is because I wonder why, and you're not the first, the plaintiffs have referenced those who have died while the treaty promises were unfulfilled. And that's an example of past harms that you say the Crown has ignored in their proposal. But I am presuming from the material, I will hear that the Crown will say they have calculated the benefits, come up with a share, and apply to bring forward rate, all of which they think does fulfill their obligation. So then the question would be, so why would they address past harms separately?
Two-part answer. First, respectfully, they apply a bring forward rate that is untethered to the needs. It's related to the Crown's benefit, but
So it's the failure of the bring forward rate.
correct. If the share is appropriate in light of these, the magnitude of these unmet needs to be reflected in the share. And if the share is appropriate, and as the First Nations suggest, we were content to compromise with the 50% share to address for this, then the other portion of the 3 big ticket items, as Mr. Schachter described it, to adequately compensate for the past unmet needs would be the bring forward rate.
Okay.
But the Crown did in fact not turn its mind to the needs of the Superior Anishinaabe, not once after 1875. And its failure to do so repeatedly cannot be rewarded. If this approach were to be endorsed by the court, there would be nothing to deter the Crown from neglecting its constitutional obligation to consider the needs of the Superior Anishinaabe and turn its mind to augmenting the annuity from time to time. If it could just simply make a one-time payment that would only address present needs another 150 years down the line, it would subvert the duty of diligent implementation to allow the Crown to rely on such reasoning today. It incentivizes the same behavior tomorrow. And that would be antithetical to any notion of responsibility, respect, reciprocity, and renewal. I'm just turning my attention to the time. I am nearly done, but I suspect I might be about 10 to 15 minutes longer. I'm in the courts,
I have no questions.
presuming that you have no, barring any questions. I'm still remaining on this topic. It's a bit of a shift, but
And how are you global for your time.
We're making great time.
Okay. Then we'll stop now.
Thank you, Your Honor.
Staff. All right, we'll break now for the day and Mr. Bass is up. Oh, you're just,
Just in anticipation, and I'll just add, we anticipate to take likely the balance of the morning. Will likely be done before the lunch break. I'm not sure how much before the lunch break, but we should be done by then.
very good. All right, we'll break now till 10 o'clock tomorrow.
Court is adjourned until tomorrow at 10 a.m.